हम बात करेंगे ऐसे दो कॉन्सेप्ट की जो ऑफन लॉ स्टूडेंट्स को कंफ्यूज करते हैं, दैट इज प्ली ऑफ गिल्ट एंड प्ली बार्गेनिंग। प्ली ऑफ गिल्ट और प्ली बार्गेनिंग दोनों ही केसेस में जो ट्रायल है वो कर्टेल हो जाता है। इट मींस इट गेट शॉर्टन एंड इट रिजल्ट्स इनटू इमीडिएट punishment if accepted by the court. The second similarity between the two is that in both the cases the application or the acceptance is made by the accused without any influence or interference. Third major similarity is that in case the decision is passed either on plea of guilt or on plea bargaining, the decision is final and is not appealable. Though in case of a plea of guilt, it can be made, but only up to the to challenge the extent or legality of the sentence passed by the court and not on any other ground. These are the three major similarities between the two concepts. Let's understand the differences. The first difference is with regard to the offenses for which it is allowed. Plea of guilt is allowed in all the offenses, irrespective of its gravity, whereas plea bargaining is allowed only in those cases where imprisonment is up to 7 years. So cases which are punishable with more than 7 years of imprisonment or life sentence or death sentence, in such cases plea bargaining is not allowed. Even cases which affects women or children are also not allowed for plea bargaining. The second major difference is with regard to the punishment. In case of plea of guilt, the punishment for the offense will remain the same which is prescribed under the law. Whereas in case of plea bargaining, some benefit is given to the accused with regard to the sentence. For example, offense is the one for which the minimum punishment is prescribed. In that case, the punishment given to the accused will be half of the minimum prescribed punishment. And if the offender is a first time offender, in that case that punishment will become 1/4. And if no minimum punishment is prescribed, in that case the punishment given for the offense will be 1/4 of the maximum punishment prescribed. Or if the offender is a first time offender, in that case it will become 1/6. Another major difference between the two is that in case of plea of guilt, it is a mandatory stage of a trial irrespective of the offense for which the trial is made. Whereas plea bargaining is not a mandatory stage. It falls when the accused makes an application. The court is not bound to ask the accused whether he wants to go for plea bargaining or not. Whereas in the case of plea of guilt, court is bound to ask the accused whether he or she wants to go for plea of guilt or not. These are the major differences and I hope it is clear, and for more such videos please like and subscribe.